Welcome to the October 18, 2022 Zoning Board of Appeals special meeting of the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. I'll start with myself, David Murch.
Greg Dean.
Tom Hennessy.
Ed Miller.
I'll mute there, Pete.
Yeah, you're muted, Pete.
Neil Lockwood.
There we
Thank
go.
Thank you.
This is a public proceeding unless the board specifically votes to go into executive session. You have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda and will be considering tonight's item in the following order. Number one, call to order. Number two, old business tabled August 30, 2022 for an administrative appeal, denied business license applicant Adam Nappy, High Wire Hydroponics. Item three on the agenda is adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights and also as a matter of courtesy, the board asks those attending the meeting with regards to a specific application not to leave until the board has completed its decision. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their names, their address, and their affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board is formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside of the meeting room. So in our agenda, we have old business tabled August 30, 2022, administrative appeal for denied business denied business license. Since that item was tabled, I need to get it off of the table. Do I have a motion for that?
So moved.
I have a second.
Second.
Any further discussion? All those in favor of taking this off the table? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Ed Miller, yes. Neil Lockwood, yes.
Very good. So I do have this appeal, having reviewed our ordinances, looking at the land use ordinance, Article 6 for Board of Appeals, specifically Section B1A. The Board of Appeals has the following authority, subject to the provisions of this ordinance, to hear, decide appeals on a de novo basis from orders, decisions, determinations, or interpretations made by the code enforcement officer or the building inspector. So based on my understanding of the ordinances, we do have the ability to hear this. Additionally, under the same ordinance, Section C5 indicates any person or municipal official or board of officials aggrieved by a decision of the code enforcement officer who wishes to request a variance from the land use ordinance or wishes a conditional use permit may file an application with the Board of Appeals. Any appeal of decision by the code enforcement officer must be filed within 30 days of the date of the decision. Now, having received a copy of Alex's decision that was dated July 1st, 2022, and the submitted appeal came in on July 22nd, 2022. So again, I believe that to be within the 30 days of the date of the decision. So given those two items, does anybody else on the board have any concerns or about how that's being looked at? I believe we have that we should be looking at this. Fred?
I just want to bring to everybody's attention
that I believe, and I don't know Adam, but I believe I know Highwire, and I believe they're the ones that purchased the building that I was just into as my business this spring. I just want to bring that up. I mean, it doesn't mean to me, I moved into a new building. I was offered to purchase that building and I denied that. But I just want to make sure that everybody knows that I was in that building at one point. I did move into a brand new building just up the street, but I just feel that I need to tell everybody that. And I don't feel that I have any problems with it, but that'll be up to Adam and his lawyer, Jeff.
Thank you. I was going to bring that up too, Fred. I appreciate that.
Okay, so I guess this is a, Attorney Wilson or Mr. Nappy, do you have any concerns with Fred sitting in on this tonight?
No, not at all.
Do not.
Okay, do any of the board members have any concerns?
None.
No.
Okay, nope, either. Okay. So before we go much further, I do want to read out loud Article 6, again, of our land use ordinances, Section C3, specifically states when the Board of Appeal reviews a decision of the code enforcement officer, the Board of Appeals shall hold a de novo hearing. At that time, the board may receive and consider new evidence and testimony, be it written or oral. When acting in a de novo capacity, the Board of Appeals shall hear and decide the matter afresh, undertaking its own independent analysis of the evidence and the law and reaching its own decision. Board members, do you have any questions with regards to that? Okay. So I guess the way we will start this, if there is Mr. Nappy, if you want to, or your representative want to bring forth, your case to us, we would be more than happy to listen to it. Then we'll go ahead, have the board ask some questions, and we'll give Alex a chance to respond. And then after that, Mr. Nappy, you and Attorney Wilson then can follow up on that. So, Mr. Nappy.
I guess I'll leave it over to Jeff to kick it off first.
Great. Thank you, Adam. Good evening, members of the board. I'm here representing Adam Nappy and Sean Haggerty on their business application made back in September of 2018. And we're here what's framed as a denial of the business license that was finally issued in July of this year. The interesting thing is that you can look at this in two different ways. You can say that this is a appeal de novo review of Mr. Sirwa's denial of the business license in 2022, or simply what I think makes more realistic sense is just affirming what was an approval by former CEO Dvorak back in September of 2018. I had submitted as an exhibit, which I think is the pivotal exhibit. I think I have share screen ability, but if you have that in front of you, there was a letter that Scott Dvorak had written to me. I actually addressed it to the Board of Appeals and Mr. Sirwa. He explains exactly what happened. There's not a lot of dispute. There's not a lot of question what occurred. Mr. Dvorak was operating as the CEO in September of 2018. Adam and Sean absolutely followed 100% of the law that was available to them at the time. In Raymond, this was before the July of 2020 new business license ordinance that we have on the books right now. So back then, it was CEO Dvorak that was approving business license. It wasn't until the referendum in 2020 that it was a select board process. So Adam and Sean, particularly Adam, submitted this business license application to CEO Dvorak. He paid in check form the appropriate fee for that license. That check was actually cash. There's no dispute about that. It shows up in his bank records. The town has the records of that deposit. The packet of the application, CEO Dvorak put on his desk. As he writes in the letter, he had every intent on putting his signature on that business license and approving it. He had made the intent, formed the intent, given the approval to Mr. Nappy. he forgot to sign that piece of paper, and it was attached behind a piece of clip paper, and he, the way he described it, it sounds like he had a heart attack when he realized come January that he had actually forgotten to put his John Hancock on the business license, and then had to call Mr. Nappy to explain to him that he had forgotten to do so. Now, under normal circumstances, that would not matter. And when he realized that come January, he could have put in his signature on that business license and it would have been no harm, no foul. Unfortunately, in January of 19 that year, the Medical Marijuana Act was amended such that all business licenses that allowed medical marijuana retail stores needed local authorization, meaning that the towns had to have on the books an actual ordinance that proactively allowed medical retail storefronts. So when CEO Dvorak realized this, he didn't know what to do. He didn't know, can I just sign this because I had already had the intent and intended of approving it in September of 18, or am I out of luck because I'm realizing this in January of 2019 after this statutory change? And I know Adam had consistently asked, what's the status? CEO Dvorak had consistently said, I'm taking care of it. I'm trying to figure out what I can and can't do. We'll address it. We'll deal with it. And Adam, being as you've seen in our meetings, very patient, always tries to give the benefit of the doubt, just sort of believe that and hope that it would resolve itself. And so that's why we're here 3 years later, because he had kept being told, we're looking into it, we're looking into it. So there was never a denial put on that business license. It was always the assumption that because it was admittedly CEO Dvorak's mistake, that this would just be corrected. And it wasn't until Mr. Serwa had actually denied it that this process came up. And so that's why I think the board's in sort of an interesting position that legally it can look at this in two ways. I think the more appropriate way to look at this is that, much like we see where it's not that there was a forgotten signature, but a misplaced piece of paper, the board always has the ability to correct that. So if we see in the minutes, for example, something is approved by the board, but, for example, a conditional license that was signed is lost, the board can fix that. If there is a septic that's approved, but the date of that septic approval is gone because the actual signed approval is gone, boards can fix those kinds of mistakes all the time retroactively, because we're not changing what the actual decision was. And because of the sort of time passage and what happened here, I would argue that legally that's the more appropriate way to look at this appeal, is not an appeal of a denial, but we're actually just correcting what is realistically a lost piece of paper. I think the letter that I'm submitting tonight as evidence is pretty open and shut that the intent was formed. Realistically, CEO Dvorak lost this piece of paper. And that's what we're correcting. It's not a denied application. And I think if CEO Serwa were to be asked, there is nothing that would prevent Adam Nappy and Sean Haggerty from this approval. There's nothing that would have caused a concern. There's nothing that would have made anyone deny this application. There's no questions about it. Under the rules at the time, the CEO would have been able to sign this. So all we're doing is correcting a missing piece of paper. But even if the board wants to look at it as an appeal of a denial, I would argue that the board legally has to look at it at the time it was submitted. Because of the delay of time, as the board's aware, there are laws that any municipal body has a legal duty to address a matter before it. Most time limits are set around 30 days. And so in this matter, where we had a piece of paper that was submitted, it took months before this error was found, and then several years before someone actually addressed it. The board should legally go back to the period when it was submitted and say that we had a duty to address this for our citizens within this amount of time, within 30 days. So by October, we should have been making this decision. And if we didn't feel it was right, stamping a denial on it so Adam could have appropriately addressed a remedy. Because that didn't happen, we got well beyond the January period, and then it just kept going. And legally, I would argue that much like we deal with ordinances that don't apply, that can't change the past, so too two, here, can we not change the facts? We need to go back to September of 18 and say, we've got a really smoking gun piece of letter from CEO Dvorak. It explains exactly what happened. And our job as a planning board is not only make it right, but to go back to the law at the time and apply it and really just correct what is a missing piece of paper. And so under all those circumstances, I would argue that the board has not only the power, but realistically almost a duty to I wouldn't even say reverse a denial, but just fix what was an approval back in September of 2018. And I would just ask that the board accept the letter into evidence that I had submitted and the application that was originally submitted by Adam back in September of 2018 as well.
Mr. Nappy or Mr. Haggerty, did you have anything you wanted to add to this at this point?
At this point, it sounds about right to me.
So I'll ask the board members, did you receive a copy of the letter which has been referred to by Attorney Wilson?
Yeah, I have mine right here.
Okay.
Yeah, I actually think it'd be helpful if you could share it. I know it's been circulated, but I just think given the
Absolutely. It says I don't have sharing abilities, but I'm happy to pull that right up if I can be given that.
I mean, that's just a suggestion to David. More, I'll let him.
Yeah, I'm certainly happy. Well, we should actually, I guess the question is, do we, well, yeah.
I can read it. I can read it verbatim if that's an easier way to do it. So he had written, it's titled Letter of former CEO Scott Dvorak regarding Adam Nappy, Highwire Hydroponics Appeal. Dear CEO Alex Sirois and the Raymond Board of Appeals. As you know, I served as the Raymond Code Enforcement Officer for several years. I was serving in that capacity on or about September 13th, 2018. On that date, Adam Nappy and his business, Highwire Hydroponics, legally and appropriately applied for a business license to sell gardening supplies and medical marijuana, parenthetical license number 2018-186. They paid for that application and permit. I accepted that permit and check for the same. The check was cashed by the town. I had every intent and had planned to approve the permit before the statutory deadline when the grandfather period ended for these licenses. That application would have been approved had the permit not been lost and attached behind a paper clip on another piece of paper on my desk. The error was on my part and not the error of Highwire Hydroponics. It should have and would have otherwise been approved back on September 18th of 2018 before any moratorium went into effect. I am hopeful the town will retroactively fix this error and grant the application I would have granted for the applicants. And then he signs it on August 22nd of 2022.
So, board, the application to the Zoning Board of Appeals, the appeal for the administrative appeal was submitted on July 22nd, 2022. So this letter was 2 months, 2 months later. So we have to really make a decision as to, I believe we need to make a decision as to do we accept this into tonight's review. Alex, I'll ask you the question. Would you have any concerns with this being considered tonight?
I don't have any concerns now.
Okay. So, board,
And if it helps on the question of the timing of the letter, I think it was about 30 days later, and I can tell you, and Adam can confirm, we climbed mountains to try and get in touch with CEO Dvorak, who's over in New Hampshire now, and it wasn't for lack of effort to try and get that in earlier, for sure. I apologize if that came in 30 days later, but we were hustling to try and get him to get that back to us.
sure. Yeah, and you're correct. That was 30 days later. So, how about I make a motion to accept this letter into the proceedings for tonight. I'll make that motion. Can I get a second?
Seconded.
Okay, any further discussion on this? Does anybody have any concerns with considering this tonight? Board members? No. So all those, I'm going to make them then, all those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Ed Mello, yes.
Ed Lockwood, yes.
All right, so that will be included with tonight's discussion. Board members, did you have any questions for either Attorney Wilson or Mr. Nappy?
I have a question for you, Dave.
Yeah.
Attorney Wilson had mentioned, and when he was speaking, that he believed that Alex would not have any questions or any reason, and that why that this letter shouldn't be accepted, I guess. I mean, is that a question that we can ask Alex?
Yeah.
Attorney Wilson brought the question up. So that's why I'm asking, can we see if we can get Alex's opinion onto that?
Yeah, and definitely Alex will be next to speak, so we can certainly get Alex's feedback, and that we can ask Alex any questions after that. Yep.
That's all.
Okay. All right. So Alex, what would you like to share with us tonight?
Yeah, so, yeah, good evening, Alex, code officer for the town. I guess first I'd like to just say thank you to Jeff and Adam for being so patient the last, longer than I've even been in Raymond, but definitely the last couple of months, definitely felt bad that they had to kind of get, you know, dragged on from meeting to meeting. So I'm glad we were able to make this work tonight. They basically summarized the history of this perfectly. It is what I believe from my actual own personal conversations with Scott Dvorak, the previous CEO, was an oversight. He would have approved the application had it not gotten attached to another and then misplaced for a few months. So I do believe that's true. Scott did tell me that himself, and you know, really my next step in that process was to essentially just run it by the town attorney, and he didn't feel as though I had the ability to approve of the business license application at that point. And it was his suggestion that my only option was to deny, which is what I did. And he provided that the applicant had the right to appeal that to the Zoning Board of Appeals and to see where that would go. So that's why we're here tonight. Yeah, that's pretty much all I have, unless you guys have questions.
And for what it's worth, I would have probably given the same advice were I the town's attorney. I think it's appropriate advice because you're not putting the onus onto a single person. It's giving it to the appeals board, which is more, this sort of thing is much more in the realm of an appellate board rather than the CEO or even a planning board, because you're dealing with the legal issues as opposed to the factual ones, which I think is, despite where it put us, I think I'd agree with that.
Board members, do you have any questions for Alex?
This is Tom. For Alex, in today's world, regardless whether this is dealing with hydroponics or marijuana sales or whatever, do all businesses have to go to the planning board to get authorized in today's, you know, whatever ordinances?
Yeah, good question. So we have essentially two different paths you can go down. If you are a business that operates outside of a home in like a brick and mortar type setting, you would get a business license from the select board. If you operate a business out of your home as a home occupation, if you work remote or have your own business where you primarily have an office set up out of your house and maybe you go elsewhere, that would be considered a home occupation. That gets approved by the code office. We do those, and they're not required to get a business license. It's a separate path. So for the most part, especially a storefront or a physical store, that would be nowadays would be approved by the select board. That was a new ordinance that went into place, I believe, in 2020.
Alex, the information that we got from Scott, you know, it was in August, August 22, 2022. Did you have any communication with Scott in advance? You denied the appeal. Did you have any communications with Scott leading up to that denial?
Prior to the denial, I did talk with Scott. I wanted to see, what his understanding of what happened with that application was. I think we actually spoke on a couple of different occasions, but most recently it was, he would have approved it. He remembers them applying for it, and it just was misplaced. He did tell me he was, planning on sending in a written statement, for them as well. So I knew that was coming.
Okay. So prior to the denial, you were aware that Scott would have approved it, or Scott communicated that he would have approved it?
Yes. Yeah.
Okay. Board members, any other questions for Alex?
I have a follow-up.
Oh, sorry, Tom. Yep.
Yeah, a follow-up for Alex. Alex, in your letter of denial there, it talks about business license for the current business or structure was issued on May of 2014 for a retail grow supply shop in correlation to an agricultural growing facility located at 13 Murray Drive in Raymond. Are we talking about 13 Murray Drive, or are we talking about 1 Murray Drive here?
I believe we're talking about 13 Murray Drive.
I think 1 is up front. Am I correct on that, Adam?
Yeah.
It's number 1. It's the up front, the one closer to the road. And one of the things I was going to add, I didn't want to interrupt when it wasn't my turn. When you were talking about the licensing, and maybe Alex can weigh in on this, one of the sort of interesting aspects of this that I think the board, I don't think it's the turning key, but it's certainly something to consider under the ordinance of Raymond. One of the things that a code enforcement officer is supplied with is a de minimis exception, I believe, that if there's no real changes to the structure of the business or the building, I believe the code enforcement can sign right off on different kinds of site plans and business models. Is that right?
Sort of, yeah.
Okay. The only reason I bring this up, and I think this is also helpful in the analysis of why it was so willingness to be approved, nothing is changing at 1 Murray Drive, except for one single product that they're selling. Highwire Hydroponics already has a store that is a retail services store that sells different hydroponic material. It would just be that they had this business license that added on the ability to sell medical marijuana products. And back before July of 2020, it was very clear the CEOs could sign off that in general. But even in today's standards, I think there's a question in Raymond if a code enforcement officer in that scenario might be able to approve a de minimis alteration to an existing site plan out there if it was such a de minimis switch as to simply the retail being sold inside, and whether there'd even need to be a separate business license for that. I don't think it's the linchpin on the reason for the denial, nor is it an underlying basis for our argument tonight. But I certainly think it's just something to throw into the mix that there wasn't much changing at 1 Murray Drive.
Okay. Attorney Wilson, Mr. Nappy, Mr. Hegarty, did you have any final things you wanted to add tonight?
I don't have anything. I think Jeff has explained most of it. If you have any questions for me, of course, you can ask.
Nope, nothing to add.
Okay.
I'm getting you out of here before 10.
Yeah, we're working on it. Board members, any final questions?
No, I see we have one other person logged in. Is that somebody that wants to go for or denied?
Yeah, we have an open public comment, but I believe that's the co-owner, Mr. Nappy. Is that your Mr. Haggerty is that who you're seeing, Fred?
He was one of the 3 applicants, actually. So the way the statutory business license is that it's when they're applying as individuals, they can't actually apply as an LLC under the statute. So Adam and Sean actually applied differently as individuals. So they're both aggrieved parties, as you would. But yeah, Sean's just one of his partners.
Yeah, Sean's a business partner.
Yeah, and this was back in 18 too?
Yes, it was the same application. The application itself, actually, it just lists the 3 people that are applying down below. And he was one of the people that applied. It was Jeff Buckley, Adam Haggerty, and Sean. Sean Haggerty, Jeff Buckley, and Adam Nappy were the 3 that applied individually. And so he was just one of the 3, and 2 of the 3 are here tonight just to watch.
Okay. So we will open this up now to public comments. Is there anyone here in the public tonight that would like to speak in favor of this application? Is there anyone here in the public tonight that would like to speak in opposition to this application? And finally, is there anybody here in the public tonight that would like to speak on this application from a neutral standpoint? Seeing and hearing nothing, we will close out public comments and close out portion of the application board. It's now our time to review this and see what we think. So again, I will reiterate what our statutes say. When the Board of Appeals reviews a decision by the code enforcement officer, the Board of Appeals shall hold a de novo hearing. At that time, the board may receive and consider new evidence and testimony, be it oral and written. When acting in a de novo capacity, the Board of Appeals shall hear and decide the matter afresh, undertaking its own independent analysis of evidence and the law, and reaching its own decision. So, yeah, I kind of just open it up to anybody that wants to share anything.
So we've entered this letter into evidence, correct?
That is correct. Yep.
Mm-hmm. And do we have any other underlying that we have to follow through other than we can accept this as evidence and make our decision off of that, or do we have to go down like any articles that they have to come by? You know how we have like the different steps we usually get down through?
Yeah, it's a good question, Fred. I have not, unless somebody is seeing something I haven't seen, I didn't notice anything specifically within our ordinances, sort of beyond what I've discussed in terms of how we need to review the things tonight. But again, if anybody has seen something.
For what it's worth, I mean, if you'd like me to weigh in for a second, I'd be happy to.
Yeah, Attorney Wilson, that'd be fine.
Sure. So in my view, and it's sort of an interesting appeal because you're looking at a pre-July 2020 business license ordinance. And so back then, when this were approved, there were no standards. My reading of the way the business license worked was just under the main statutes, which essentially says that when any individual plans on operating business within town, the town shall provide a person that shall enter in paperwork at the town to record the business. And I think the statute refers to it at least being the town clerk, but there can be more. So there's no standards under that pre-July 2020 rubric that Raymond had. It was unless the CEO had a major concern, at which point he'd bump it up to the planning board for review, he would approve it, or he or she would approve it. And so unlike, for example, when the ZBA is hearing an appeal of a site plan review, it has to appeal and then look at all the standards to see if they're met. But in this case, I think it's really just a question of if the appeal should be granted, and we look back, if it was going to be approved and the CEO confirms that, it meets the one standard, which is it shall be approved. That was my take when I was looking into that question.
Thank you, Attorney Wilson. Alex, in fairness, did you have anything you wanted to add to that?
No, I don't have anything else to add. I don't disagree with, the process as he described.
Thank you. So I guess I'll from my perspective, certainly reading Scott's former CEO's letter, he was a former code enforcement officer at Raymond. He indicates that he would have approved it. And on that one side, per Scott, it should have been approved, and there was an oversight in which it was not approved, and a deadline was passed, or at least a milestone date was reached for which it couldn't necessarily be approved. But then I also hear what Alex had to say with regards to the town attorney stating that to go ahead and deny it based on current statutes. So I'm kind of, we're here to, it's my understanding, to make a correction to something the code enforcement officer may have done in error. And we have a town attorney advising Alex to go ahead and do it based on current statutes. So I put that out there to the board to discuss as well. I kind of, see it both ways.
Well,
Can
I speak?
on that? Oh, sorry, Fred. No.
Go ahead, Fred.
No, Mike, I was just going to mention that, getting back to where Alex mentioned that he, brought this up to our attorney, the town attorney, and the town attorney and Attorney Wilson said that he would do the same thing, is that I don't think that the town attorney wanted to put this onus onto Alex by himself. That's why I'm listening. I heard it. And I think even Alex, if I understood him correctly, he doesn't oppose this license going through, because it should have gone through back when, Scott was doing it. And I think that the Raymond attorney is just trying to make sure that it's covered the correct way and not put on one person. But maybe I'm not listening, I'm not understanding it correctly.
That's what I heard too, Fred.
And I do think that I wasn't obviously privy to the conversations, but I do think the attorney, had he felt strongly that the ZBA didn't have this authority, I think would have given much stronger advice to say, not only should you deny it, but this should be denied at the appeals board, and it's a question for the Superior Court. And no way in any shape or form would I ever approve this. I think what he really did was say that it's just the appeals board decision. It's not the CEO's decision at this point because of the date that it's being done. So I read that the same as the way Pete and Fred did.
David, can I have a go at it? Yeah, I think you probably said yes, so I'll start.
Yes, I did. Sorry. No, go ahead.
Yeah, I think I'm saying the same thing, but just here's my thought process. And I think there are lots of things that the code enforcement officer can't kind of unilaterally do, and requires zoning board kind of oversight for. Like a variance is one, like you can't approve a variance. And this in a sense is a variance from what he could have done at the time. So my thinking is that we're here just for a formality, and we should probably just, these guys waited long enough for a license. But my thought is, like, we're just merely a formality on what is the statutory restriction that the CEO has, and that the zoning board is here specifically to approve it.
Alex, I have a comment or two. Or
Yeah.
Dave, sorry.
Yeah. No, go ahead, Tom. Yep.
I guess I asked those couple of questions to Alex, trying to figure out what authority, today is required to open up a business. And I'm a little leery of the zoning board even taking on something that the select board today needs to approve for any business. So just my feelings that maybe we're overstepping our bounds. Maybe the lawyer didn't tell us that, but he told Alex that. So a little leery in proceeding forward on this.
Well, hard to really know exactly what was said to Alex. Not sure how much we can read into that, whether or not he said it suggestively that it should not be approved or suggestively that it should be approved is kind of well beyond, I think, the scope of what we can interpret.
Fred, Pete, anything further?
I mean, it would have been nice to know if the attorney did say that it should go to the select board, but I mean, Alex didn't, to me, I didn't see him or feel that he made that kind of a statement that, it needed to go there. I think that he still, again, said that he had talked to Scott, and Scott would have okayed it. I think if I read Alex's way he was talking, that, he felt that it should have gone through at the same time, because of what Scott said. And, these guys have been waiting since 2018 to get an answer.
Hey, David.
Yeah.
Looking at the ordinances, Article 6, Section B, where it talks about powers and duties of the zoning board. The way I read that and interpret it, it sounds like this absolutely does fall under our responsibility to take a look at this and interpret the information provided to us and make a decision based on Alex's actions.
And I didn't want to interrupt. I was going to say the same thing, Pete, in response to Tom's comments, is that the interesting thing about this hearing is it's de novo. And so the concern that Tom had, I think would definitely apply a little bit more if it was a straight appeal where you can only consider the record and what was said previously. Because it's a de novo appeal, I think, you're deciding in realistically what's that. And my argument is whether you're looking at what Scott did or you're looking at what Alex did, the board is actually substituting its own decision for what should have occurred on whatever date it's considering. It's because it's de novo. I agree with Pete wholeheartedly on that.
I'm gonna, given the information that we received from Scott, specifically his statement of the application where it said it should have and would have otherwise been approved back on September 18, 2018, before any more a moratorium went into effect. We have the former code enforcement officer indicating it should have been approved. We have the former code enforcement officer indicating that it had been misplaced, lost. And I agree that, looking at this, I'm looking at this from, back in September of 2018, should it have been approved at that point, and everything from my perspective, everything that I'm seeing and hearing indicates that it should have been approved back at that time. So at this stage, I'm going to make an motion to approve this appeal and that the business license should be approved. Do I have a second on that?
I'll second that.
Okay, and we'll have final discussions on this. Anyone?
I have,
Yeah, you echoed it. I mean, your points are well taken. I think Article 6C5. I mean, you could just as well argue as Jeff did that the decision to not immediately file the business license application or is the issue that we're remedying. So whether or not we're not actually granting a license. So I think it's spot on. Right. That's the thing you cited, or the ordinance you cited in the beginning of this. So I think we're well with it's exactly what we need to do.
So, well, I guess I want to make sure I'm understanding correctly, Greg. I'm assuming that if we accept this appeal, then we're changing a denied business license to an approved business license. I guess we should be in agreement on that. That's what we're doing here, correct? If we vote for this motion as yes, we are accepting the appeal.
Yeah, I'm just trying to address the bifurcation of how you look at it. There's the what's the actual wording used, the aggrieved by a decision of the code enforcement officer. And what I'm saying is the decision that I think is causing the problem, it's not Alex's decision, it's the failure to successfully consummate the original business license. The net effect is the license is issued, but we're not actually evaluating whether or not this license should be or shouldn't be. We're just trying to fix a mistake that was made. And I think that's a much easier thing to reason about. You know, we talk about what are the standards that would be viewed today from the select board and all that stuff. I just don't think it matters. I think there was a decision to not file it correctly, and we're fixing that and issuing the license today.
can I just say something? I don't think there was a decision not to file it, right? I think it was just a forgotten paperwork that didn't get processed through, correct?
Well, yeah, but he decided to put it on his desk. He could have taken it. He could have taken it by hand. I mean, there's a sequence of decisions that resulted in it not being done correctly, and that is what's brought us to this point. Somebody's been agreed. You know, there's a issue from a decision of whether or not it's filed.
I hear what you're saying, Greg, but the decision. We're looking at Alex's decision to deny. That's the actual where this aggrieved party is coming from. And that's where the appeal came from. That's where we had to look at, within the 30 days. So it is aggrieved by Alex's decision. However, looking at it from the de novo perspective, looking back at it from back in 2018 at, September 18, 2018, should it have been approved there? And we have a former code enforcement officer. It's not his decision that we're looking at tonight, but a former code enforcement officer indicating, the code enforcement officer at the time indicating that he would have approved it.
I don't even think we're discussing whether it should be if there's merit of it being approved or not. I think what we're trying to fix is that there was a mistake made when it was originally approved.
Yep.
So That's all I'm trying to say. Maybe I'm making it more complicated, but that's my thought process. So of you know, what decision got us here that we're fixing, or
Right.
we're creating a variance of or from.
Yep.
And I hear what David's
totally
saying, and for what it's worth, from my end, I think David, you're right that the motion should probably be phrased as accepting the appeal and reversing the decision and granting the license. And the reason I say that is mostly because of what the agenda is. If the agenda is put out to the public as we're addressing an appeal, it might, I mean, I think both the way Greg and the way David are phrasing it gets to the same end result. But just in terms of like minutes and books, it might, I think you might want to phrase the motion as we're granting the appeal and retroactively, if that's the direction you're going, would be to make the motion as the appeal is allowed and take the vote on that, so that it matches the agenda. If that makes sense.
It does. So we can undo the motion, I guess. And appropriately apply the wording. Board members, do you have any concerns with that?
No.
Okay, so we will withdraw that motion. And I will make a new motion to accept the appeal, the administrative appeal for denied business license, thereby retroactively approving the business license. So that's the motion. Do I have a second?
Seconded.
Okay. Any further discussions with regards to that?
None for me.
Okay, so I will go ahead. We'll move forward with a vote. Dave, so just to be clear, in favor, we're accepting this appeal, and allowing the business license to be approved, just to be clear on this. So David Murch is in favor.
Greg Dean, yes.
Tom Hennessy, no.
Fred Miller, yes.
B. Lockwood, yes.
Okay. So 4-1. So, Mr. Nappy, Mr. Haggerty, gone ahead and voted in favor of this appeal. So get a decision written up here within the next 7 days, and I'll get that to Sandy.
Thank you guys very much. And again, thank you very much for having us on a special night. I appreciate that. And I give you guys a ton of credit for having been at the last two meetings. Patience of saints.
Well, thank you. All right. Last item on our agenda is adjournment. Motion to adjourn.
So moved.
Seconded. All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
B. Lockwood, yes.
Very good. Thank you, everyone.
Have a good night,
evening.
everyone.
Have a good night.
Thank you very much.